हेलो व्यूअर्स, ये यूट्यूब चैनल लेक्स कॉन्सिलियम फाउंडेशन की प्लेलिस्ट इनसे मिलिए। मैं मेजर जनरल नीलेंद्र कुमार यहाँ पर बात कर रहा हूँ प्रोफेसर बीटी कौल साहब से। और इस बातचीत का मेन मसला है आप सबको और मुल्क में जो सुप्रीम कोर्ट के जज जस्टिस उज्जवल भुयान ने एक स्पीच दी पूना में, और वहाँ पर उन्होंने सुप्रीम कोर्ट की कॉलेजियम का वो मसला उठाया जो कि जस्टिस अतुल श्रीधरन से ताल्लुक रखता है। एंड ही इज was sitting judge of Madhya Pradesh High Court, from where he had come from J&K High Court. तो Justice Atul Sreedharan was elevated at Madhya Pradesh High Court, और वहाँ पर उन्होंने एज ए जज एक सुओ मोटू नोटिस लिया जिसमें कि मध्य प्रदेश गवर्नमेंट के एक मिनिस्टर ने कुछ बयान दिया था जो कि अच्छी लाइट में नहीं था। उसको बोला गया कि स्कलियस अटैक था वो रिमार्क्स जो थे, एंड विच रिलेटेड टू वन कर्नल सोफिया कुरैशी। नाउ शी इज अ सर्विस ऑफिसर आर्मी की, और शी along with one of her colleagues from Air Force, these two women officers had were the spokesperson during Op Sindoor, और इन लोगों ने काफ़ी तारीफ का काम किया था, और वहाँ पर ये रोज़ टीवी पर देखे जाते थे along with the foreign secretary। जो मंत्री जी के विजय शाह के रिमार्क्स थे वो पसंद नहीं आए थे और उसकी सो मोटू नोटिस ली, और ये कहा गया कि एज अ रिएक्शन टू दैट ऑर्डर बाय जस्टिस अतुल श्रीधरन, a case was taken up by the union government for transfer of the judge from मध्य प्रदेश हाई कोर्ट। जैसा आपको मालूम है कि इसका अख्तियार, इसकी पावर अथॉरिटी सुप्रीम कोर्ट की कॉलेजियम में है। वहाँ ये मामला आया और वहाँ पर डिसीजन लिया गया कि उनको वहाँ से भेज दिया जाए छत्तीसगढ़ हाई कोर्ट में। उस आदेश के, उस डिसीजन या रिकमेंडेशन अगर मैं कहूँ, उसके खिलाफ फिर सेंट्रल गवर्नमेंट ने अप्रोच किया कॉलेजियम को फॉर अ रिकंसिडरेशन, और फिर सुप्रीम कोर्ट की कॉलेजियम ने एक निर्णय लिया, फैसला लिया कि उनको छत्तीसगढ़ के बजाय इलाहाबाद भेजा जाए। और ये फैसला सुप्रीम कोर्ट की वेबसाइट पर लिखा गया था। पहला वाला शायद अवेलेबल नहीं था जो छत्तीसगढ़ के लिए था, लेकिन छत्तीसगढ़ के बजाय इलाहाबाद भेजा जा रहा है। दिस वाज रिफ्लेक्टेड, appeared on the Supreme Court website, and it was mentioned there that this has happened at the instance of the government, asking the Collegium to reconsider. However, this part subsequently, after some time, was removed from that portion, that the action was at the instance of the central government. तो इसके ऊपर जस्टिस उज्जवल भुयान ने, जो इस वक्त सीरियल नंबर 18 पर हैं सुप्रीम कोर्ट के 33 जजेस में से, वो असम हाई कोर्ट से आए हैं और अभी उनको 3 साल और सुप्रीम कोर्ट में रहना है। उनका टेन्योर है 1 अगस्त 2029 तक, 2029। तो इसकी काफ़ी अहमियत ली गई। द मीडिया टुक नोटिस ऑफ इट। आप लोगों ने, जिन्होंने देखा, इंडियन एक्सप्रेस ने इसको कवर किया, इसके ऊपर एडिटोरियल तक निकाला, जजिंग जजेस। इंडियन एक्सप्रेस ने कहा, स्ट्राइकिंग इंट्रूजन, सुप्रीम कोर्ट जज फ्लैग्स गवर्नमेंट इंटरवेंशन इन जुडिशियल ट्रांसफर्स, और इट इज गवर्नमेंट डिक्टेटेड ट्रांसफर शो इरोजन ऑफ जुडिशरीज ऑटोनॉमी। ये इस तरह के काफ़ी हेडलाइंस आई, और इनसे ये सवाल उठ रहा है कि क्या कुछ बेसिक क्वेश्चंस आ रहे हैं। पहली चीज़ कि क्या independence of judiciary, does it form part, does it lie within the basic features of our constitution? क्या गवर्नमेंट को कुछ अख्तियार है कि जजेस के अपॉइंटमेंट और ट्रांसफ़र भी इंक्लूडेड है अपॉइंटमेंट में, कि इसमें वो इंटरफियर करे, रिकमेंड करे, कहाँ तक ये मुनासिब है, कहाँ तक कॉन्स्टिट्यूशन में ठीक है, ये भी सवाल उठा कि जुडिशरी की इंडिपेंडेंस, इज इट एक्चुअली सो, इज इट अ रियलिटी और इट्स अ मिथ? Times of India stopped or concluded its editorial piece by saying that the grandest of rhetoric is no match for demonstrated independence. Obviously, they felt that independence should be visible, so much so, not merely talked about. और ये भी आया कि क्या गवर्नमेंट का कोई रोल है जजेस के ट्रांसफर में? कुछ आर देयर एनी जेन्युइन ग्राउंड्स जिनमें ये होना चाहिए? और अगर कॉलेजियम गवर्नमेंट के कंसिडरेशन पर किसी जज का ट्रांसफर कर देता है, डज इट अमाउंट टू इंटरफेरेंस इन जुडिशरी? इज इट ये जस्टिस उज्जवल भुयान को कहना कि द बिगेस्ट थ्रेट टू द जुडिशरी इज फ्रॉम विद इन? इस तरह की जो बातें हो रही हैं, तो हम समझते हैं कि एन एमिनेंट लीगल एकेडमिक like Professor BT Kaul is suited, is required to comment on this. He has almost about 5 decades experience. 34 साल से ज़्यादा वो दिल्ली यूनिवर्सिटी में उन्होंने बहुत इज्जत और सम्मान के साथ पढ़ाया। उसके बाद दिल्ली जुडिशल एकेडमी के हेड रहे और उनका रिसर्च, उनकी पीएचडी तो दिल्ली यूनिवर्सिटी से है, लेकिन उसके बाद वो लंदन स्कूल ऑफ इकोनॉमिक्स में भी उनको जाने का, वहाँ रहने का मौका मिला। सो आई एम वेरी थैंकफुल टू यू प्रोफेसर कॉल, एंड यू हैव हर्ड दीज ओपनिंग रिमार्क्स टू स्पीक.
General Saab, it's such a great pleasure to be on your platform once again.
जी
I have had the pleasure of meeting Justice Atul Sreedharan
जी
with National Judicial Academy, where both of us were resource persons in one of the programs for the High Court judges.
उस वक्त कुलीग थे
He,
आपके?
हाँ, मैं नहीं, वहाँ हम दोनों we were speaking on in the same session.
ओह
So
अच्छा अच्छा
what my information is that he was appointed as a judge
जी
in Madhya Pradesh High Court,
ओके
was transferred to J&K High Court.
ओके
He was again transferred from J&K High Court back to Madhya Pradesh High Court.
करेक्ट
And then, because of his, that I thought a very proactive judge,
जी
he had the courage to take a suo motu action
जी
and issued notice to the minister and also suggested whether the why the FIR should not be registered against him.
जी
I think it was a very courageous move from a judge. I think very few judges who have courage
जी
to, follow the law and rule of law and be wedded to the rule of law. I
ओके
think Justice Atul Sreedharan is one of those proactive judges
जी
who has a lot of respect for the dignity of every citizen of this country, who
राइट
has respect for the rule of law, and therefore he did what was the constitutional morality. And that's
ओके
what we generally talk about, is a judge, when he takes an oath, whatever his ideology is, whatever his, biases,
इंक्लिनेशन
biases may be there in the mind, but he has to have only one philosophy, that is the constitutional values and constitutional morality. And that is what must permeate all the decision makings and all the actions that a judge is expected to do. There was one of the judges of the Supreme Court, Singhvi. What he said in National Judicial Academy, where both of us again were resource persons, he said, every day when I sit in the court,
जी
I read the oath that I have taken. I reread it every day so that I am committed to what is the constitutional morality expected from him, and that must permeate his decision making in the court. Now, whole of the debate as to whether the power to appoint judges and transfer judges should vest with the executive or it should be with the court or the collegium. The collegium is basically a concept which was evolved in the judges transfer cases 2 and 3, because they overruled the first transfer judges the
जी
case. And in that case, they said uh, independence of judiciary is a basic structure of the constitution.
So that
And
is
therefore,
undisputed now.
it is which has almost become it cannot be gone back to. It's something which has become a,
Come
a
to be
part of
accepted.
our constitutional morality.
Ji.
And therefore, we are wedded to the concept that anything that has to happen, judges appointment and transfer must be the exclusive domain of the collegium. Of course, there was an attempt when we made 99th amendment to the constitution, and then we enacted NJAC, and both these changes that were tried to be brought in, they were struck down because they said it is violative of the basic structure of the constitution in the sense of independence of judiciary. Now it will compromise the independence of judiciary. Therefore, the kind of law that was brought in according to the judgment, it was something which was not, what we call as it is non-negotiable. In fact, what we say is independence of judiciary is non-negotiable. And
Right.
when we talk about, it is the primacy of the collegium, and especially the transfer of judges is an internal matter, and executive has no role in it. And if the executive is meddling into it and is impressing the collegium to go by what its dictats are or its recommendations are, I think that is where the basic structure doctrine is getting violated. You see, people in this country have great faith in the judiciary. People here, they consider the last resort of the bewildered and the weaker and vulnerable sections of the society. Therefore, it is the judiciary itself which has to be the guardian of this trust that the people have imposed in them. And therefore, that's what Justice Ujjal said, that we, the judiciary, have the great responsibility. We have to stand erect, and we do not have to allow any kind of intrusion into the independence of the judiciary. And therefore, if this voice has come within from the court, you see, this is second situation when we see four judges when they gave a press conference. But whether what came out of it, I do not know. What it could be the positive effect of that press conference. But today, a sitting judge himself is saying that what was done by the collegium was not in conformity with the independence of judiciary. Therefore, they should not have at all allowed the influence of the executive in the decision making. The process is independent process. Executive has no role so far as you see, the purpose of transfer of judges is to helping the administration of justice. There may be a judge who is needed in one of the benches and somewhere else because the cases that are dealt with by that court are his specialization. And he is a person who can guide the other younger judges, and therefore it is needed in the better administration of justice. There cannot be victimization, there cannot be a punishment. Transfer cannot be a punishment. Transfer has to be to help the process of justice to be administered properly and in a better manner. I think
in the interest of justice.
It is in the interest of justice only, and nothing more than that. Now, if a judge, according to his constitutional morality or what he thinks is the constitutional morality of a judge, thinks that howsoever powerful a person may be, but he has to follow the rule of law. He cannot make utterances which are not acceptable, and those are in contravention of the law. Therefore, an action must be taken in the situation. It doesn't warrant transfer of a judge from one place to another place, and that too when the collegium had decided to send him to Chhattisgarh. But at the initiative, because there are chances that a person who is at Chhattisgarh may have got a chance to become the Chief Justice. Now you send him to the larger High Court where he will be one of those crowds, in the crowd, and therefore such judges will not get an opportunity to, guide the future judges. I think that is very important for us to understand. And I think if this has been said by a judge who is a sitting judge and he has commented upon what are the minutes of the collegium, it is not that it is something hearsay. It is what was recorded in the minutes of the collegium. Why they are transferring Justice Atul Sreedharan to Allahabad is because government had recommended that he should be transferred instead of Chhattisgarh to Allahabad. I think this is something which is contrary to the judgments that have been laid down by the Supreme Court itself, talking about collegium having the supremacy both in the matter of appointment as well as the transfer of judges.
थैंक्स कौल साहब, आपने बहुत क्लियरली बताया। लेकिन अब इस स्टेज पर आप क्या समझते हैं, व्हाट इज द वे आउट?
You see, I think we must. I think that's what, if he could be recalled back, I do not know whether he has retired or he is still on the bench. If he has not retired, I think the fitness of things, he should be asked, requested if he would like to go back to Madhya Pradesh High Court or the one which was chosen by the Collegium, that is the Chhattisgarh High Court. I think this is what is the minimum thing that is needed in the given situation. Now, this will itself have the effect of implicitly annulling the recommendation of the executive. I think that's what is least expected of the Collegium now.
Thanks. You have articulated it quite clearly. The other thing that I would request you to sort of throw light is, what according to you is the reason? Because जो बात आपने कही वो इन judges की भी समझ में आनी चाहिए, but despite that they succumb to the pressure and take actions. What do you think are the reasons, the cause for the Collegium to behave in the manner that they did?
You see, we have some past experiences also, like, Justice Akhil Qureshi,
जी,
Justice Muralidhar.
जी,
Now we have Justice Atul Sreedharan,
जी,
whose case we are discussing today. I think what we need is, we need the judges to re-look inside, and the collegium needs to be, you know, applying its mind and, giving a call to its conscience as to why should it not restore back the faith of the people. Like, I give you an example. You
जी,
see how much time it took the Supreme Court to again regain the legitimacy after the judgment it delivered in that ADM Jabalpur's case.
जी,
It almost lost the total legitimacy. Now, how much of struggle it had to do? It had to then keep the doors ajar, open the doors for the downtrodden and weaker, and build up a new jurisprudence, public
जी,
law jurisprudence or public interest litigation. Yeah, a letter to the Chief Justice or a judge of the Supreme Court could become one of the writ petitions that could be taken up by the court, and any public interested person could come and bring the cause before the court. Now, this is how much of struggle Supreme Court had to make in order to regain its legitimacy, which it lost in ADM Jabalpur's case. So,
yes,
therefore, court must be conscious. History should not repeat itself.
जी,
History should be set right. Sooner the better. And the collegium needs corrections. And I think that is very important. And it is good that now inside voices are coming out. And we are told by the judges, sitting judges, like, he talks about in the same lecture, he talks about the liberty, how important the liberty is, and how important the duty cast upon the judges is to preserve the liberty and not to make inroads into the liberty of the people in an unjust manner. Now, that is something which the executive is capable of doing every day. And judges are supposed to be the guardians of the constitution and guardians of the human rights of the people. That is why people have so much of faith in India about the judiciary. And it is an institution which has stood the test of time. But I think it's high time that we should again expect the judiciary, especially the collegium, to go back to the drawing board and see as to how it can make the correct corrections and objectively decide every case of appointment on merits, every case of transfer, only and only on the consideration of administration of better manner the justice to the people of the country.
thank you very much. You have really explained the entire case, bringing out the background and also pointing out the way ahead and what needs to be done. Thank you very much.
Thank you,
And
sir.
this sort of discussions will continue. Thanks for coming here.
God bless you, sir.
Thank you.
Thank you very
Thank you.
much.